Judge Barrett, thank you again. 4 cases: U.S. versus Lopez, D.C. versus Heller, Hobby Lobby versus Burwell, Washington versus Glucksberg. Were they correctly decided? Got to put your mic on.
Is it working now?
Yeah.
Okay, good. Senator Tillis, I can't express a view on the correctness of any precedent.
So I think it's pretty clear that it's not just cases favored by my Democratic friends. You're taking a very consistent position, and I think the American people should understand that. Thank you. I had a sheriff in Wake County. In North Carolina, you have to apply for a permit to purchase a handgun in North Carolina. And for a period of time, the sheriff of Wake County refused to process handgun permits. He has subsequently reversed that policy, so it's no longer an active case. But, you know, it would seem to me that that sheriff was making a decision that wades into, I think, a Second Amendment right. How would you evaluate a case like that if it came before you?
So if a case like that matured into litigation and went up the appellate process, I mean, I would look at the law, and obviously the Second Amendment would be relevant there. So I would, read all applicable precedents, including Heller, to determine whether what the sheriff had done violated the Second Amendment right or not.
Well, I think in that case it did, but I would leave it to somebody far more qualified than you to take it forward. And I suspect it will if the sheriff reimposes the same imposition on lawful gun owners. I thought about this when Senator Hawley was asking a similar question. I've finished my 68th telephone town hall since the first case was reported in North Carolina. And about a month into it, everybody understood that we had to shut things down, try to understand how COVID was affecting us. But then about 4 to 6 weeks later, we saw peaceful protests, some of which were hijacked, and we've seen them widely reported, allowed by certain liberal governors and other elected officials in towns and counties. But at the same time, they prevented churches from being able to worship. You enumerated the protections, the specific protections under the First Amendment, and I think religion and protest are 2 of them. Do you feel like any governmental entity has a right, on the one hand, to allow these protests to occur, and on the other hand, prevent worship in temples, synagogues, mosques, or any place of worship?
Well, Senator, those kinds of cases are being litigated all around the country right now. Some have gone up to the Supreme Court on a couple of different orders, so those aren't things that I would be able to comment on.
Are you able to opine at all on how you would go about evaluating the arguments?
Sure. So whenever you have that kind of a restriction, like, as we are in a pandemic, the Supreme Court's general position is that the government has a compelling interest in responding to a health crisis of this sort. So you look at the case law describing the extent of the state's authority to address a public health crisis. It's come up before in a case involving vaccination. Then you also, and this was clear in my interchange with Senator Hawley, you also look at the other amendments and other rights at play. So in the case that I had, it involved the First Amendment, looking at the speech and free exercise clauses of that amendment. So those come into play as well.
Thank you. When I met a couple of weeks ago, I have to thank you again. My daughter was thrilled that you signed the 2 pocket constitutions for my 2 granddaughters, and they'll cherish it someday when I can explain what it really means. It's going to take a few more years. One is 3 and the other one's 8 weeks. But, I really enjoyed that discussion. And I ask you there something I'd like for you to share with the committee. You have stellar academic credentials. You have stellar record as a professor, and you've done an excellent job on the 7th Circuit. You've been a great mother and wife. You have so many options. There are so many things that you could be doing besides going through the first confirmation hearing, which was not pleasant. I was here and I remember it. And you knew that this was even going to be more challenging. So I asked you when we met, why would you do this? Knowing how this was going to play out, knowing that you were going to be attacked and unfairly treated, and I think to a level of maybe where some of your constitutional rights have been questionably denied. So why are you doing this, Judge Barrett? Why not just say thanks but no thanks, leave it for somebody else?
Well, as I said to Senator Graham yesterday, and I think this was part, and parcel of the conversation that you and I had, that this is a very difficult process. Actually, I think I would use the word excruciating over the weeks, and the knowledge that, people are going to say horrible things, that your entire life will be combed over, that you'll be mocked, that your children will be attacked. And so one might wonder why any sane person would undertake that risk and that task unless it was for the sake of something good. And as I said yesterday to Senator Graham, I do think the rule of law and its importance in the United States, and I do think the role of the Supreme Court is important. It's a great good. It would be difficult for anybody in this seat. I think everybody knows the confirmation process is very difficult, and so for me to say no, other people could do this job, but the same difficulty will be present for everyone. And so for me to say, I'm not willing to undertake it, even though I think this is something important, would be, a little cowardly, and, I wouldn't be answering a call to serve my country in the way that I was asked. I also think in our conversation, I said, that my children were part of the reason not to do it, because, my son Liam got very upset yesterday during the questioning, and so, we had to call him in the car. He didn't stick it out to the end. I was surprised he stuck it out as long as he did. But Liam got very upset at the questioning, and Senator Kennedy referenced some of the other things that have happened to the children in the process, and so I said to you before any of that happened that in many ways the children are the reason not to do it, but they're also the reason to do it, because if we are to protect our institutions and protect the freedoms and protect the rule of law that's the basis for the society and the freedom that we all enjoy, if we want that for our children and our children's children, then we need to participate in that work.
Well, I think you're an extraordinary role model to a lot of people watching. I agree with Senator Blumenthal. A lot of people are watching this, and I hope that every one of them conclude that you're a courageous person and you're a public servant. With your credentials and your experience, you could move out of public service and do virtually anything you wanted to and have more time with your family along the way. And the fact that you're willing to serve is just, I think, an extraordinary testament to your character and your integrity, and I appreciate you for it. The other thing I wanted to get back to is on the issue of abortion. I think it's remarkable over the course of the past couple of days how many times they have, my colleagues on the other side of the aisle have challenged you on this matter. And in the same breath, they're advocating for activism. In one breath, they want to secure certain Supreme Court precedent. On the other breath, they want your commitment to potentially overturn it. But I want to talk specifically about a policy in Gonzalez versus Carhart. I mentioned yesterday late-term abortions, partial birth abortions. I've thought were horrific all of my life, but especially since I held that premature granddaughter of mine who was born 3 weeks premature. How would you, if a case as a matter of state law or federal law, let's say Senator Graham's bill, how would you go about evaluating maybe some laws that would prevent late-term abortions, partial birth abortions? How would you go about evaluating that in light of Gonzalez versus Carhart?
Well, I would look at all the precedents. Casey, as we discussed yesterday, sets out the undue burden standard, which is the test, and then Gonzalez versus Carhart, as you say, upheld a restriction on partial birth abortion. Whole Women's Health and June Medical are the most recent cases in the abortion line. So if I were to have to decide a case involving a bill like the one that Senator Graham has referred to, it would involve looking at all of those precedents and their application to the particular contours of the law that was before me.
Thank you. Now I'm going to go in a slightly different direction. I was talking with Senator Coons, who is the ranking member on a committee that I chair, a subcommittee here on intellectual property. We've done a lot of work, and we're working on a bipartisan, bicameral basis, and I have to thank Senator Blumenthal for probably being one of the more active members in this committee. I think it's an area where we really are working on a bipartisan basis, the things that the public seldom see. But I want to ask you first on antitrust. I know a district court opinion sided with Federal Trade Commission that found that Qualcomm violated antitrust law. And the Ninth Circuit overruled that district court decision. I don't know if you followed it, but in the Ninth Court opinion, they said that Qualcomm was a company just asserting its economic muscle with vigor, imagination, devotion, and ingenuity. I know you can't speak to that case, but I'm interested in your thoughts generally on antitrust law. Where do you think the court should draw the line on federal antitrust limits between where a company violates an antitrust law or, as Qualcomm was characterized, of just asserting its economic muscle with vigor, imagination, devotion, and ingenuity?
I haven't followed that case, so I'm not aware of that case from the Ninth Circuit, but I would be venturing out into that hypothetical dangerous territory if I tried to articulate what hypothetical line to draw in the context of antitrust law because, well, as you probably know better than I, just being on the committee, it's a complex area with lots and lots of precedent and lots of statutory and regulatory law as well.
Moving to another area that's been addressed on the Committee on Intellectual Property and Patent Law Eligibility. As judge, I should say, as chairman of the subcommittee, I'm really interested in protecting the intellectual property of the American innovation economy. There's no question that we're the leader in the world. But in recent years, we've seen a lot of Supreme Court cases that have waded into patent eligibility, producing a series of opinions that have really muddled the waters. And in some cases, I think that I agree with the decision, but I worry about the methodology that they use to get there. So I'm curious about your thoughts. In my committee, we've talked about specific cases that we could potentially abrogate if we could get bipartisan support, and we're in those discussions. But what are your thoughts on the Supreme Court's rulings on patent eligibility? And do you think that the court should go back and clarify at least the method that they use to reach their opinion?
So without commenting on any particular cases, which actually I have to be completely honest and confess to you, I can't think of what particular cases you might be thinking of in the patent eligibility, but without commenting on those cases in any event, I think I would say that clarity in decision-making is always something that courts should strive for, and I know on the Seventh Circuit, we try to be attuned to in writing opinions, whether it gives good guidance to lower courts and then to also those who are trying to order their conduct, in compliance with the law. So I think clarity is certainly a virtue in this context.
And I think that we're working, like I said, on a bipartisan, bicameral basis to help or do it on our part. Copyright law and technology is another area that we focus quite a bit on. I think I had one witness say that our current laws are MySpace laws in a TikTok world. There's a lot of changes that have occurred, and we feel like there's a need for us to maybe move forward with some clarity and some protections. The Supreme Court has spent more than a century answering questions about whether copyright law covers new technologies like cameras, player pianos, moving pictures, the list goes on, several internet-enabled technologies. Do you think that the Supreme Court is the best institution to answer these questions, or is that a role Congress should play?
Most of the things you're identifying sound to me like matters of policy, and so those seem like matters that are best addressed by the legislature, a democratically elected body, not policy made by courts.
I agree. I think it's a complex subject, and I'm glad to hear your opinion, and I hope that we make progress on it. And again, I have to thank Senator Coons and Senator Blumenthal and Senator Hirono, who are on that subcommittee, I think we've worked well, and I'm hopeful that we'll make progress. I think Senator Blumenthal asked you about the courts getting involved in elections, but before somebody goes out into the cyber world and says 9 people are going to decide the outcome of the election, 9 votes versus the tens of millions of votes that are being cast now will be cast by November the 3rd. What you're potentially going to be confronted with are various lawsuits that may come in based on changes in voting protocols for this cycle versus other ones. But at the end of the day, what role is the court going to play, if any, in the determination? 9 people are not going to elect the president, regardless of who wins the election. But 9 people are going to have to consider various cases. But at the foundation, is it accurate to say that your role will be determining whether or not every single American who wishes to vote had their vote recorded and was given proper access to make that vote? Is that fundamentally what the courts would decide?
Fundamentally, if an election dispute arose, obviously the issue, it's impossible to predict what particular aspect of the election would be challenged. But the laws that would be invoked are laws that protect the right to vote, that keep elections fair. So those are the kinds of issues that have come up in past election disputes. And so certainly the court would not see itself as, and would not be electing the president. It would be applying laws that are designed to protect elections and protect the right to vote.
I also want to thank you in closing, Mr. Chairman. I want to thank you for reaffirming, I think in a discussion with Senator Durbin, possibly Senator Hawley, that you believe every single person in this country should have a right to vote, and that they should be able to do that without intimidation, without any undue burdens. And I appreciate you reaffirming that. And I just want to make sure I heard you right in your responses to other questions. You do feel very strongly that every American should have safe access to the vote. And I, for one, hope that every registered voter in this country vote on November 11th. That may be a stretch goal, but do you agree with that?
Of course, yes.
Thank you, Judge Barrett, and thank you for your family for enduring all the challenges that you have. Thank you for your courage, and thank you for your integrity. I look forward to supporting your nomination.
Thank you, Senator.